You're looking at body-worn camera footage cam. It's just past 11 p.m. on a Thursday, a quiet residential street. Porch, lights glowing. The officer walks up the front path, takes a deep breath, and pounds on the door 3 hard knocks. Then a pause, then 2 more police. "We just need to talk to you for a second." The door stays shut, and right here, before the person inside says a single word, the trap is already set. Most people think the danger is in what they say. It's not. The danger is in what they do next. Because one instinct, one natural human reaction, is what transforms a knock on the door into handcuffs, a search, and a charge that never needed to happen. By the end of this video, you'll know the 4 words that shut it all down, and the body of law that backs those words up so completely that even the most determined officer knows the conversation is over. The timestamp in the corner of the footage reads 11:07 p.m. The officer adjusts his belt and glances back toward a second patrol unit idling at the curb, then knocks again. "We've got a complaint about a disturbance. Just want to ask a couple questions. Can you open the door?" I've been a criminal defense lawyer for over 20 years, and I have watched this exact scenario turn into a conviction more times than I can count. Not because the person inside was guilty of anything, not because the police did something illegal, but because the person inside didn't understand the single most protected physical space in American constitutional law, the threshold of their own home. Let me walk you through what the law actually says. Right as you're watching the footage play out on screen, because the officer's body camera is about to capture a textbook example of a knock and talk, and that technique is not some casual conversation. It's an investigatory strategy designed to get you to voluntarily give up the protection your front door is supposed to provide. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And the Supreme Court has been painfully clear for decades the home is where that protection is at its absolute peak. In Peyton v. New York, the court held that warrantless entries into a home to make a routine felony arrest are presumptively unreasonable. In Kylo v. United States, the court said any physical intrusion into the home, even a technological one, is the chief evil. That any physical intrusion into the home, even a technological one, is the chief evil against which the wording of the Fourth Amendment is directed. That word home carries more weight than a car, more weight than a bag, more weight than anything else you own. So why, you might be thinking, can the police just walk up to your door and knock? Because coming to the front door is considered a customary social practice. The court said, as much in Florida v. Jardines, there is an implicit license for a visitor, including a police officer, to approach the home, knock, and wait briefly to be received. That's the knock and talk. No warrant is required to knock. The officer is standing in a place any Girl Scout selling cookies could stand. But the moment you open that door, especially if you step outside or allow the officer to step inside, you begin to chip away at that constitutional protection, not all at once, but decision by decision. And the footage we're watching right now is about to show exactly how that erosion plays out. The officer leans closer to the doorframe hem. "Sir, I can hear you inside. Just step out and talk to us real quick so we can clear this up." Notice the language "step out." That's not an accident. If you step outside, you have just moved yourself from the most protected zone to a zone where the legal calculus changes. Once you are outside your home, the officer may be able to detain you with reasonable suspicion, arrest you with probable cause, or even claim you consented to a broader interaction. And if the door is left open behind you, the plain view doctrine might allow them to see something inside that then becomes probable cause for a search. On the body cam feed, we see the door open about 6 inches. The chain lock is still on. The face of a man in his 40s appears in the gap. He's squinting, clearly woken up. What's this about? This is the inflection point. The officer now has a visual on the inside, and in many jurisdictions, what he can see through that gap is fair game. As if it's in plain view, a bong on the coffee table, a prescription bottle without a label, even something as innocuous as a firearm case sitting on the floor. Anything the officer can see from a lawful vantage point can become probable cause. And probable cause plus exigent circumstances can justify an immediate warrantless entry. That's the rule from cases like Kentucky v. King, where the court said that police may enter a home without a warrant if they have probable cause and circumstances create an urgent need to act, such as the destruction of evidence or a risk to officer safety. So that 6-inch gap is a window into your entire private life, and whatever the officer sees in that gap can escalate the encounter faster than you can close the door. The man inside doesn't know it yet, but he's holding all the power right now, and he's about to give it away with the most common mistake I see. Answering the question, he says, "There's no disturbance. My girlfriend and I were just watching a movie. I don't know what you're talking about." And that answer, as innocent as it sounds, just handed the officer exactly what he wanted: engagement. The officer now knows that there is another person inside. He knows the man is willing to answer questions. And he knows that if he keeps asking the man is likely to keep talking. And talking is the engine that generates the reasonable suspicion necessary to prolong the stop, or the probable cause necessary to justify a search. In Terry v. Ohio, the court allowed brief investigative detentions based on reasonable suspicion. But it's the knock and talk context where reasonable suspicion gets built in real time. The officer doesn't need it to knock, but the moment you start answering questions about what's going on inside, you're feeding information that can be used to justify a detention. Or worse, the officer says, "Mind if we come in and just make sure everything is okay? I just need to see that your girlfriend is safe." Now, the officer is using what's called the community caretaking exception. This is a real legal doctrine. Police can enter a home without a warrant if they have an objectively reasonable basis to believe someone inside is in immediate danger. But the exception is narrow now. In Coniglia v. Strom, the Supreme Court unanimously rejected. Community caretaking is not a free-floating exception. The idea that the community caretaking doctrine creates a free-floating exception to the warrant requirement for homes. The police cannot manufacture a wellness check out of thin air just because they got a vague call. But here's the problem. Once you open the door and acknowledge that another person is inside, the officer can frame that as a reason to believe that person may be in distress, especially if the call that brought them there claimed a disturbance. The man hesitates. We can see it on the footage. He looks back over his shoulder, then back at the officer. He's trying to decide if he should just let them in, to prove nothing is wrong. That instinct is so deeply human. You think I'm innocent? I have nothing to hide. I'll just cooperate, and this will end. But the Supreme Court has made it clear your willingness to cooperate can be used against you. In Schneckloth v. Bustamante, the court held that consent to search does not require the police to tell you that you have the right to refuse. They can just ask. And if you say yes, that's considered voluntary. So if you say, okay, I guess you can come in, you have just waived the warrant requirement for the entirety of your home. Anything they find is admissible. The man in the video looks at the chain lock, hesitates again, and then he does something I wish more people knew they could do. He doesn't slam the door. He doesn't yell. He doesn't try to argue about the law. He looks through the gap and says very calmly 4 words. "I want a warrant." That's it. Not, "I do not consent. You can't come in. Get off my property." 4 words. "I want a warrant." Those 4 words invoke the full force of the Fourth Amendment without being confrontational, without giving the officer any new information, and without stepping 1 inch outside the threshold. The moment you say that the officer knows that any further entry without a warrant, absent a true articulable exigency, is a constitutional violation, and anything he finds will be thrown out under the exclusionary rule from Mapp v. Ohio. He can stand on the porch, he can ask more questions, but he cannot cross that threshold without either your consent, a warrant, or a genuine emergency. And you've just withdrawn your consent and made it clear. You expect him to follow the warrant process. On the body cam, you can see the officer pause. He shifts his weight. He says, "We're just trying to check on a report. You don't want to make this harder than it has to be." The man doesn't argue. He doesn't explain. He just repeats, "I want a warrant." And then he quietly closes the door. The chain lock rattles back into place. Legally, at that moment, the encounter is effectively over. The officer does not have consent to enter. He does not have a warrant. And if he tries to force his way in without an exigency, every piece of evidence he finds will be suppressed as fruit of the poisonous tree. That's what happened in Wong Sun v. United States. And it's been the bedrock of exclusionary rule doctrine for over 60 years. The police can remain outside. They can try to get a warrant. They can even set up a perimeter while they go find a judge. But they can't just kick down the door because you refused to let them in for a chat. Now, I want to be careful here because some people hear a phrase like, "I want a warrant," and think it's a magic spell that makes the police vanish. It's not. If the officer does have an actual exigency, smoke pouring out of the window, someone screaming for help inside a credible report of a violent felony in progress, that warrant requirement falls away. Exigent circumstances override the warrant requirement, and the courts will examine those circumstances later with the benefit of hindsight. So these 4 words are powerful, but they are not a shield against a true emergency. The key is that you are forcing the officer to have that exigency be real and articulable, not just manufactured out of your cooperation. But what if the officer doesn't have an exigency and just keeps pressing, "If you don't open the door, I'll get a warrant and it'll be worse for you"? That's a negotiation tactic. The officer is allowed to bluff, but you are under no obligation to play the game. You've made your position clear. You want a warrant. If he can get one, he'll come back with one. If he can't, he can't. And the most common reason he can't is that there's no probable cause to search your home in the first place. In Illinois v. Gates, the concept of a totality of the circumstances test. The court adopted a totality of the circumstances test for probable cause. That means the affidavit for the warrant has to show a fair probability that evidence of a crime will be found inside. A vague noise complaint is rarely enough. A hunch never is. I want to zoom in on one more detail from the body cam footage before it cuts. After the door closes, the officer stands there for about 20 seconds. He radios and mutters something about the resident being uncooperative, and then walks back to his cruiser. His partner gets out. They confer quietly, and then both of them drive away. No arrest, no search, no evidence. The entire incident ends the way it legally should, with the home still intact. That is what the Fourth Amendment looks like in real time. The man inside didn't need to quote case law. He didn't need to argue about his rights. He didn't need to guess whether the officer had probable cause. He just communicated in 4 words that he understood the most important boundary. In constitutional law, the boundary between the public street and the private home. That boundary is protected by centuries of legal tradition, reaffirmed by cases from Semane's case in 1604, which declared that a man's house is his castle, all the way through Florida v. Jardines in 2013, where Justice Kalin wrote that the front porch is part of the curtilage and that bringing a drug-sniffing dog to the front door without a warrant is a search. Warrant required. The principle has held your front door is not just a piece of wood, it's a jurisdictional line. If you're watching this and wondering whether you have to use those exact 4 words, the answer is no. The underlying right is what matters. You could say, I don't consent to any search, or you need a warrant, or even, am I being detained, or am I free to go, depending on the situation. But at your own front door, the clearest, least confrontational, and most legally precise thing you can say is exactly what that man said. I want a warrant. It's polite, it's final. And it doesn't give the officer any new facts to use against you. There is a whole separate conversation about what to do and they actually show up with a warrant. And that's a video for another time, because the rules change the second a judge's signature is on a piece of I.